Hi, and welcome to this latest immigration law update video. In this video, I'm going to look at the important subject of electronic filing in the Upper Tribunal, composite electronic bundles, and the submission of new evidence as part of that. Now, that might not sound like a sexy subject, but it is an important one, because there has been a number of recent practice directions and guidance notes from the senior president of tribunals, the president of the Upper Tribunal, and the principal resident judge at Field House. And what we don't want ever as practitioners is to be reported to our governing body or to have costs awarded against us. So this is really important for those of you who conduct appeals in the Upper Tribunal. So I've shared my screen, and I've shared my screen from the very helpful website EIN. I'm sure you're familiar with EIN, but these are publicly available on EIN. And the first thing I've shared is the new practice direction from the senior president of tribunals, Sir Keith Lindblom, that was set out on the 31st of August 2023. So I'm sure you're familiar with this. It's been around a few months now. I'm recording this in January 2024, but I want to go through it. So it's the practice direction of the Immigration and Asylum Chamber of the Upper Tribunal, electronic filing, E-File. And you'll see from paragraph 1, the practice direction applies to all proceedings in the Upper Tribunal, including applications for judicial review. Paragraph 2 says that E-File is the online system for filing documents electronically at the tribunal. That's the secure portal, which is referred to at Rule 13 of the procedure rules. Now, just a note here, E-File is an online filing system. It is not a case management system, so it's different from my HMCTS in the first tier tribunal. Look at paragraph 3. On or after the 1st of September 2023, any document provided to the tribunal by a party who's represented or a body that's amenable to judicial review must be provided using E-File, unless the document is an application for urgent consideration as defined in the practice direction. So the shortest sentence of them all, paragraph 4, users must register to use E-File. The next tab I'll show you on my screen is the registration tab for filing and registering with E-File. So all of you watching who lodge documents with the Upper Tribunal, make sure you or your firm has registered with E-File. Do it today. Keep those January New Year's resolutions to keep up to date with law and practice and register with E-File. I'll show you the link and the guidance now. Then 5, any document provided to by E-File to the tribunal must consist of 1 copy. It's in PDF format, unless it's a draft order that should be in Word format. Mustn't exceed 50 megabytes or such other limit specified, and must be characterized or labeled as the type of document that it is. Then the bundle must be prepared in a way that complies with the guidance issued by the Chamber President. And we're going to look at the guidance issued by Mr. Justice Dove in a moment. 7, E-File cannot be used to provide documents to another party. So you're still going to have to email your bundle to the Home Office at the usual UT Directions email address I'm sure you're familiar with. The requirement to use E-File will cease if a matter is transferred to another tribunal in which the use of E-File is not mandatory. So if a case is remitted back to the FTT, you won't then have to use E-File in the FTT, because the FTT doesn't use E-File. So let's look at my next tab, and that is, and I put all the links to these tabs in the description to the video. But this is the screen you'll see in order to register for CE file. So if you're an OISC representative, a solicitor, perhaps a barrister who does direct access case and might need to use CE file and file documents with the tribunal, here's where you register. This is the guidance provided by HMCTS on using the system. So familiarize yourself with this guidance. I'm not going to go through this guidance, but do make sure you're familiar with using it. And now here is the guidance provided by Mr. Justice Dove, the President of the Upper Tribunal Immigration and Asylum Chamber, in relation to electronic bundles and using CE file. Now, this is really important. So what he says in paragraph 2, this guidance supplements the practice direction issued by the senior president, and that's the one we went through. 3, to use CE file to file documents, users must first register as an e-filer. So I've given you that link and shown you how to register. When you make an application for permission to appeal, it will be assigned a CE file reference. And paragraph 5 shows you what the CE file references will look like for a JR matter or for an upper tribunal matter. And you need to use those references in all correspondence. And here's the important bit in terms of electronic bundles. So any electronic bundles you provide for the upper tribunal must comply with this guidance. And look, they say about considering they're using their powers under Rule 10, so we don't want cost orders against you. So bundles must be no more than 50 megabytes. You want a single PDF not exceeding 50 megabytes. And in the guidance, it's going to show us how we can reduce the size to make that achievable. If you really can't do it in one 50 megabyte bundle, you have to split them up into the smallest number of PDF files. Look at paragraph 8 and make that clear from the file name. So you put the UT reference and it's UT bundle part 1. That's the example they give. Paragraph 9 is important in relation to pagination. For those of us who've done appeals using electronic bundles, what the judge often wants to know is what's the PDF number, because they're trying to scroll through. So what it says at paragraph 9 is all pages of the bundle, including index pages, must be numbered in ascending order, preferably by computer generation or at least in type form, and not numbered by hand. So stop numbering bundles by hand. Get them computer generated. And the important thing is, if you make page 1 of the index, page 1 of your bundle, the PDF numbers should match the page numbers, and that'll make everything much easier. The digital PDF page number must correspond to the paginated page number. Paragraph 10 says that. Where it's necessary to split a bundle, continue the pagination. So if your second part, your first part finishes at page 300, it gives the example, your second part should start at page 301. And just to note back on paragraph 10, a system of numbering which compromises a letter and a number, e.g. A1, A2, should never be used. Paragraph 12, a digital index or table of contents must be prepared. The index should be hyperlinked to the pages or documents it refers to. And then significant documents and significant sections in the bundle must be bookmarked for ease of navigation. Now, in preparing for this video, I did some Googling, and it's very easy to find guides online how to bookmark sections of the bundle. And you probably are using in your practice a particular PDF software that creates PDFs, and it should be simple to hyperlink and to bookmark. And remember, paragraph 14, bundles should be provided in a PDF format, which is suitable to use with Adobe, PDF Expert, or PDF exchange editor. You don't have to use those, but it must be suitable so somebody using those can read and use your bundle. Paragraph 15, default display view size of the pages must be 100%. Documents must appear in portrait orientation. Now, paragraph 17, forgive me, is important. All bundles must be text-based, not a scan of a hard copy bundle. I still see sort of scanned hard copy bundles with handwritten pagination. If there are documents within the bundle that have been scanned, you need to use optical character recognition, which will then allow the judge or whoever's using the bundle to search and highlight parts of the bundle. Now, in order to reduce the size of your bundle and keep it within 50 megabytes, and I still get massive bundles transferred to me on a regular basis, reduce the resolution size, paragraph 18. So it must be reduced to between 200 and 300 dpi. And you also should use file optimization, and that'll reduce the size further. If you're going to provide a draft order or draft directions, that should be provided, paragraph 19, in a Word document separately. And when you're naming a file, it must include the UI or JR reference and, where necessary, an indication of the number of the bundle. Again, at paragraph 21, there's reference to the guidance, and that's the guidance that's open on my third tab and the links below. And then there's also a link to the FAQs on CE file and an email for support. So if you're struggling, email the support. I know somebody contacted me recently where they're struggling to lodge a JR by CE file. So you may want to use that to contact to try and get some support. Now, finally, standard directions in represented appeals. So Principal Resident Judge Blum from the 25th of September 2023 has provided these standard directions. So this is what your bundle should look like in substance. No later than 10 working days before the Upper Tribunal hearing, the appellant is to provide the Upper Tribunal and the respondent with a composite electronic bundle which complies with the guidance on the format of guidance for electronic bundles. So that's what we've just gone through from Mr. Justice Dove. Now you'll have to upload it to CE file and email it to the Home Office. But notice, if the Home Office is the appellant, they should be providing this bundle. Now it should be in parts A to D. Part A is the decision, the grounds, the grant of permission, any Rule 24 response, etc. Now, I said at the start of this video, we'd cover new evidence. If you're going to provide new evidence to the Upper Tribunal, you have to submit it under a Rule 15.2a application. So that application should be at Part B with the new evidence submitted behind it in Part B. Part C is the appellant's evidence before the FTT, and Part D is the respondent's evidence before the FTT. I do wonder, actually, if Part C and D could be combined and you could use the stitched bundle that was prepared by my HMCTS, but we'll have to see if that's acceptable to the Upper Tribunal. But do make sure you follow the pagination rules in Mr. Justice Dove's guidance. Interpreter requirements no later than 10 working days before the hearing. Now, if you're going to rely on a skeleton argument, this doesn't mandate skeletons, paragraph 3, but if you're going to provide a skeleton, no later than 5 working days before the hearing, and it must be in sequentially numbered paragraphs, not less than 12-point text, no more than 20 pages of A4, and it not extensive quotations, and be cross-referenced in the format in E. If the respondent is going to provide a skeleton argument, no later than 2 working days. Now, the notes, don't ignore the notes, because this is really important. And again, we don't want cost orders to be made against the parties. Don't assume Roman 3 that the Upper Tribunal will have anything that was before the FTT. They make particular note, paragraph Roman 4, about the requirements of Rule 15.2a, and in terms of new evidence. So the presumption is, in accordance with the practice statement, that any remaking of the decision will happen at the same hearing as the error of law. Now, I know in reality that doesn't often take place, but the party should be prepared and ready for it. So any new evidence provided under Rule 15.2a should be provided before the error of law hearing and should be put in Part B of that bundle. But where there's a separate subsequent remaking hearing, and since the error of law hearing, there's a further Rule 15.2a application and further new evidence submitted, what the appellant should do there is insert it into Part B and effectively provide then an amended composite bundle for the remaking hearing. Look at Roman 5. Where the respondent, Roman 6, intends to rely on additional evidence, they provide it in a separate bundle no later than 10 days before the hearing. Now, these directions must be complied with unless they're varied, substituted, or supplemented by further directions. And I've certainly had cases recently where they've been supplemented and a skeleton argument has been mandated by the Upper Tribunal. So some really important guidance there on filing electronic bundles and by CE-File, and filing documents and applications to the Upper Tribunal by CE-File, and also the format and the contents of those bundles. Do look at the guidance, do follow it, because we want to avoid cost orders and problems in the Upper Tribunal, and hopefully this will help you achieve success in your cases in the Upper Tribunal. All the links are below. Thanks for watching.